phone lines and return to the matter of Richard Jakpa in court and the cross-examination and speak to Lawyer Eric Delanyo Alipola. Good morning and thank you very much for your time.
Sir, good morning to you and to your staff over there and to all listeners of Radio Gold.
I hope you're well.
Yes, I'm doing very well. Yes.
He's president of Lean Sword, and it's nice to have you on the line. I'm sure you've either read stories around what transpired in court yesterday, or you've had the opportunity of going through a record of the cross-examination and examination of the Mr. Jakpa. What do you think? What are your observations?
Well, thank you very much for the opportunity. We have been talking about this matter for some time now, almost 2 weeks now. And I don't think that anything has changed very much because I still hold on to the belief right from the onset that there was a gross misconduct by the Attorney General and that should have ended the trial. So what happened in court yesterday, I was not in court actually, I was in court the 2 previous adjourned dates, but yesterday in particular I was not in court, but I monitored everything because it was being reported while the testimony was going on. So what happened in court is just further emphasis was just added to all that we knew already, and further information was provided for us to see that the misconduct was far more than we knew, and so that's it, and so nothing changes my position that this trial should have ended. But the good thing is the tape recording was admitted into evidence yesterday, and then the accused person provided further particulars about discussions that had transpired between him and the Attorney General. So initially when those motions were filed by counsel for the first and third accused persons, and the tape was admitted in evidence, many people mistook that, or they thought that it meant that the tape was admitted into evidence in the real matter, in the substantive trial. At that point, I took the opportunity to explain to a few people that it was only admitted for the purposes of the motions that were filed in court at the time. And that was shown yesterday when counsel for the first accused, Honorable Atofosin, actually took steps to now tender the tape into evidence in the real matter, and it was admitted into evidence. So we'll see once the matter is admitted into evidence, it means that the contents of the tape is relevant for the determination of the case. That's what it means, because relevancy is the most pervasive concept in evidence law. So whatever evidence you have, that when you attempt to put it in, there will be opportunity given to the other side to either express consent for it to be put in or to object to it. And once there's objection, somebody has to determine whether the evidence is admissible or inadmissible. So, and the main factor in determining that is whether the evidence is really relevant, whether it will help in determining the matter. So, this is what happened in this matter as well, when the lawyers of the first accused person tried to put the evidence in. I believe the Attorney General, yes, that's what I heard, he tried to object to it on grounds that somebody's privacy was violated and all of that. But the judge ruled that it should be tendered. It means that the judge actually made an assessment and realized that the contents of the tape are relevant for the determination of the matter. And so once it's now admitted, we'll see how relevant it will be, the weight that will be put on it, and how it would affect the trial. In my view, like I said already, the conduct, especially when the judge did not dispute that the voice on the tape was that of the Attorney General. At the time she was determining those motions, those applications that were filed by the first and third accused persons, I believe strongly that they should have just ended the matter at that point. Yeah, but well, she didn't. It's because it's not a normal occurrence. There are no precedents in our jurisdiction very much about things like that, and so maybe she didn't have the courage to go all out and say that, well, this really has prejudiced the whole case, has rendered the whole case nugatory, and so it should be there should be mistrial. She couldn't do that. But we are waiting to see how the evidence would influence the rest of the case till the final judgment.
And that was what I was coming to think of, some bit of education, because this is a matter that has to do with the substantive matter has to do with a contract for the procurement of ambulances, and whether or not the person who was the contract was followed to the letter, and improprieties that the EG said it has identified in the delivery on this contract. Now, how does these issues of meetings between the Attorney General and an accused person, how does they help in getting to the bottom of this matter, especially when the judge decided it was not going to perhaps grant the application for a mistrial?
Well, like I said, once the judge admitted it into evidence, well, there can be a second thought also. But obviously, the lawyers are going to address the court on the value, the probative value of this evidence once it's now in evidence. After all the evidence is taken, the lawyers will address the court in a written submission, and they will tie everything. They will try to let the judge see how this should affect the matter. So if in the course of the trial, when those applications were put, the judge didn't think that the trial should have ended at that point because of this evidence, but she thinks that the evidence is still relevant and will be material in determining the matters. The lawyers will have to put up a very strong case why it should be seen, or it should be assessed or evaluated in favor of the accused persons, and the accused person should be acquitted and discharged. And we are hoping that, in fact, that is the only, for me, that would be the only obvious conclusion. Anything apart from that would show that there's injustice, clearly, in my mind, because, like I said, and I'm never changing my position, that this tape should have ended the matter at the time it came out anyway. But, well, they say the law lies in the bosom of the judge. And again, I've always also said that the judges, they are also human. And there can be various reasons why they may not rule in a particular way. And I am not one of those people who believe that we should always be forced or compelled to accept that every ruling of the courts are based on their true assessment of the law. They are human beings. Anything could influence them. And so whilst I'm not making any allegation against a particular judge right now, I'm just saying that generally, the judges, sometimes there are considerations that are extraneous to the matter that determine how they rule. And we hope that that will not be the case in this matter.
But you said, based on the evidence you had yesterday and the reports that are coming out, the misconduct was worse than we thought.
Yes.
Why do you say so?
Yes. Well, on the tape, we had, it was kind of like a teaser. Once more information is carried out, it appears as if a teaser that, we had Attorney General's voice and all of that. Now, we know the particular times that they had the meetings, and the meetings were had in the night. Why would Attorney General want to meet an accused person in the night? And so that should also be seen that there's something nefarious, something dubious. Otherwise, he should just out boldly invite the accused person to his office in a full glare of everybody. In any case, he knows that what he was doing was wrong, because he shouldn't be talking to an accused person. And the judge in the ruling on those applications did say that she was surprised that the Attorney General would be talking to an accused person on a matter that was active in court and discussing the evidence with the accused person. Yeah, so she did this in the dark. And then we had a number of meetings they held. And then also in the house of a Supreme Court justice, nobody is going to that area very much, and I can understand why. So when you look at all of this, and then it went on to also even state the motive. You see, the motive is the reason why somebody will be doing a particular thing. That's the motive. It's not really an element in criminal prosecutions or in criminal charges. But the motive helps in establishing that indeed whoever committed the crime had the intent to do it. And so this one, they told even the motive that, look, we want to get Honorable Ato Forcing to jail, even if it is for only 1 month, so that we can have a by-election. And then when we have a by-elections, fancy people are cheap. So we can go and throw money at them and they will vote for us. So that we'll have one more seat in parliament than NDC. And then perhaps the NDC people will now come back begging us for the release for pardon of Honorable Ato Forcing. And then we'll use that opportunity to get them to do whatever we want to do, to agree with us in parliament, whatever we want to do. That is a motive, a clear motive why and then also another motive why we heard that there was a point where we heard that they said that this case had to end, and I heard the judge even said it that by the end of May she has to decide this matter. Now, clearly the Attorney General's discussion with Mr. Jakpa also indicated why anybody or why the state will be interested in getting this matter resolved by the end of May. Because they said that's why he said is that you cannot hold by-election in less than 6 months before the general election. So if the matter ends at the end of May, then there will be 6 clear months. It will not be less than 6 months. So quickly there can be by-elections. And then they're thinking that plenty people are cheap. They can carry money and go and pour on them, and then they will vote for MPP candidates. So that is motive also. So all of these were revealed yesterday. And that is why I'm saying that it's West. It's West now. It's put out a lot more information that we knew about 2 weeks ago.
To how important is the motive for prosecuting a case? Because I was also thinking that even if the motive was as devious as is being shown now, well, if you have a strong case against the person, should that not be good enough?
Yes. You see, the motive is, and it plays out very much in cases that the prosecution relies mostly on circumstantial evidence. So if, for instance, there's murder and you cannot establish clearly that the accused person is the one that murdered the person, you cannot show any physical evidence. The accused person was not seen murdering the person, he was not the last person that was with the person and all of that. Then motive that this accused person actually wanted the victim to die could help in establishing, in tying up all the pieces of evidence that you are providing that you think should make a judge or jury convict that person as the one who committed the murder. So the motive, if you can show clear motive that this person had wanted the victim to die all along, and there are circumstances that you can establish, then that may help. So motive is important because, you see, if this, in this particular case, Attorney General and his department are denying, he didn't meet, he had enough evidence already to nail the accused persons and all of that, blah, blah, blah. Then we are now hearing that, this is what they wanted to do. And if we were in any doubt, that Honorable Ato Forcing was the only one that Attorney General was looking for, that the President and discussing the Finance Minister were looking for to be jailed, then the testimony now that shows the motive clearly that the reason, because now everybody is saying, the reason why it's Ato Forcing is because look at the way Parliament is balanced and look at the way it's been hitting at them. So maybe it's true. If this man goes to jail, there probably would be, not probably, there definitely would be a by-election, and they probably indeed will send money there. And I don't believe that the fancy people are cheap. NDC people do not believe that fancy people are cheap. We regard them in high esteem. But MPP does, because Attorney General clearly stated that they are cheap. If we go and pour money on them, they will stop thinking, and they will vote for us. So that is a clear motive. So motive can help. So in the judge also even evaluating the evidence, if he's not very sure, you see, it is not only what they told them in court previously in trying to struggling in any way. He was actually struggling. Attorney General was struggling really to make a case. Otherwise, he would have been appealing to Mr. Jakpa, who knew more about the contract than anybody else, because he was an agent for Big C. He would be telling him to accept a particular theory that he thinks that would help him to punish one person. So if Mr. Jakpa is telling us that these are all the reasons why the Attorney General was doing this, for us, and for many of you in the media, you only be seeing what the Attorney General is trying to do in court, and then pretending to tell us how he has evidence. Oh, they just want speedy trial. That is why they want the case to end in May, blah, blah, blah. Sometimes they will even be saying that it is in the best interest of the accused person for the trial to end early and all of that, you know. But the motive now, you will now see that, oh yeah, the reason why they wanted this trial to end in May is because they wouldn't be able to do a by-election if the case is going to end after June. So you see how motive can help you to understand some of the things we heard earlier, which we couldn't make much sense of. So that's how motive can even help even a judge or even a jury in evaluating cases. And so it is, though it's not one of the elements, it is important to let whoever is going to determine the facts, like a jury or judge, to see that, well, there's a clear motive, and that should be taken into account in evaluating the rest of the evidence that was heard in court. So motive is important.